Good evening, everyone. My name is Josh Blackman, professor here at South Texas. It is my honor today to present to you Ilya Somin. Ilya is a professor at George Mason Law School. More importantly, he was my property professor. So everything which I taught you wrong about property, several of my former students here. Just don't blame him. I was a bad student. Ilya has been at George Mason for a number of years. Terrible student. He clerked for the Honorable Jerry Smith here in Houston. Actually, he's in town for Judge Smith's reunion. He's the co-editor of the Supreme Court Economic Review. His works appear in the Wall Street Journal, Los Angeles Times, Washington Post. You may know him as the blogger on the Follow Conspiracy, where he blogs on common law and property issues. He is not Ilya Shapiro, who actually was here a few months ago giving a write-up. They are, in fact, different people. We have a contents to prove it. But perhaps most tragically, Ilya is a Boston Red Sox fan. And his penchant for suffering is no doubt how he managed to be in his class for a year. But we see that Ilya has been a good follower of the Red Sox for many years. Today, Ilya will be talking about Kelo v. New London. And if I may, a brief introduction. In 2005, the Supreme Court held in Kelo v. City of New London that the government can take property for purposes of economic development. So the Constitution says there needs to be a public use to take property. And the Supreme Court said, if there's economic development to be had, property can be taken. This case resulted in what can be called a backlash, in that a lot of states started enacting laws trying to say, hey, this is bad, we'll get more property protection. Very famously, Judge Posner wrote that political responses to Kelo is, quote, evidence of the decision's pragmatic soundness. In other words, courts shouldn't be jumping into this and deciding what property rights are. The people should through the legislatures. So a lot of states passed these laws. One such law was Texas's Amendment 11, which Ilya will talk about, which tried to limit the scope of what property can be taken for public use and public development. As Ilya will talk about, it wasn't very effective. So without further ado, I will introduce my former professor and my good friend, Ilya Somin.
I'd like to start by thanking Josh and the South Texas Federalist Society for organizing this event. This is the first time that I've had the honor of being introduced by one of my own former students. It makes me feel proud, but also kind of old. So, when you get to this phase of your careers, you'll know what I mean in saying that. But more seriously, we are certainly very proud of Josh and all of his tremendous achievements. If you look at his website, you'll see that he already has more publications than most people have when they come up for tenure, and he's also a very prominent legal blogger, and has a long list of other impressive achievements to his name. So one could say perhaps that in many ways he's achieved more, not only more than any other George Mason law grad of such recent vintage, but perhaps more than any other graduate of any other law school anywhere who's graduated just in the past 2 or 3 years. However, before moving on from the subject of Josh, I have to warn all you Texans that there is sadly one gap in his education for which we at George Mason bear a heavy burden of responsibility, and that is that to this day he has not read either The Hobbit or The Lord of the Rings, and therefore he is completely unqualified to teach you the important property law issues that arose in those books, including Elven property rights, Dwarven property rights, and of course property rights and rings of power. I have tried to correct this flaw in his education, but sadly it may reflect my weakness as a teacher, but sadly I have failed. I hope you will have more success, and as he's here in the Lone Star State, he will be inspired to read these important works of property scholarship, and even more importantly, that he will give up his misguided support for the evil empire of baseball, namely the New York Yankees, which is entirely incompatible with many of his other beliefs, such as his belief in limited government.
But it's compatible with winning. It's very compatible with winning.
Not in this century, it isn't. In this century, they've only won the World Series once, despite massively outspending all other teams. Only half as many times, therefore, they've won as the Red Sox.
We've done this before. So
yes. So I could devote the rest of this lecture to talking about the Lord of the Rings, the Red Sox, and the Yankees, and it may be that it would be more popular if I did so. However, I'm at least in theory supposed to talk about Kelo versus City of New London and its aftermath, and so that is what in fact I'm going to attempt to do. As Josh said, Kelo is a case decided by the Supreme Court in 2005, where they were interpreting the public use clause of the Fifth Amendment, which was generally interpreted to mean that you can only condemn property if there's some kind of public use. However, in Kelo, they said that you can condemn one person's private property and give it to another private individual simply on the basis that that might result in some economic development. I say might because the government is not even actually required to prove that the economic development is going to occur. Now, in my view, this was not actually a very good decision by the Supreme Court at all. However, I'm nonetheless very grateful to them that they decided it because I've gotten 5 or 6 articles out of it. It helped me get tenure. I have a book contract with the University of Chicago Press to write a book about it. So thanks to the Supreme Court's misguided decision here, there have been great benefits to my career, even though the public interest may have suffered. So the Supreme Court rarely does what I tell them, as you can see from the fact that they cited my amicus brief in Kelo and yet still voted the wrong way. But to the extent that they listen to me, my message to them is I hope they keep up the bad work, because some of us need things to write about, even people like Josh who don't have tenure yet and maybe therefore in even more need than I am of continued bad material from the court to help us write about. So in this talk, I'm going to start out by briefly talking about what economic development takings are and why they're problematic, more problematic than most other kinds of condemnations are. Second, I'll talk about the Kelo case itself and some of the doctrinal problems with it, why I think the court's conclusion was misguided. I'll devote the bulk of my talk to the political and judicial reaction to Kelo, which is in many ways the most interesting but less known part of the story. After Kelo, 44 states, including the great state of Texas, passed eminent domain reform laws. This is a record. No other Supreme Court decision ever in all of American history has resulted in so much new legislation at the state level. In addition, there has been extensive consideration of Kelo and its legal implications in both state and federal courts, and I'll talk about some of those. And I'll also talk about why it is that many of the reform laws, including, sad to say, those in Texas, don't really reform what they claim to reform and don't actually achieve the results that people like Richard Posner predicted that they would. In my view, political ignorance played a big role in that story. So, as I noted earlier, economic development takings are a condemnation where you take property from one person and give it to another on the theory that doing so might result in increased economic development. And since World War II, we have actually forcibly displaced hundreds of thousands of people with these kind of takings and with the closely related blight and urban renewal condemnations, so this is not a small problem. Obviously, almost any use of eminent domain, or really any use of any kind of government power, there's some risk of abuse, but with economic development takings, the risk is unusually great. One reason why that is the case is because in the states which allow these sorts of condemnations, the new owner of the condemned property and the government which does the condemnation is not actually legally required to produce the economic development that supposedly justified the condemnations in the first place. So you get results like this. This is in fact the Kelo condemnation site today. There are buildings in the background, but that's not actually the condemned property. The condemned property is in the foreground. Nothing has actually been built. Why? Because their plan was actually shoddy. The developer that they hired couldn't actually build anything on time. Now, eventually something will be built, probably. They're hoping to do so, but in the meantime, the land will have lain empty for many years. That's obviously a significant economic loss, even aside from the personal pain and social costs inflicted on the owners of the condemned property, and also millions of dollars in public money was spent to condemn the property, clear the site, make plans, and so on and so forth. So this taking is a net loss for the people of New London, even in purely economic terms. However, it's fair to say that there are actually some beneficiaries of the Kelo takings. It turns out that a colony of feral cats has taken over the site, such as this lovely animal right here, and so they are benefiting from the condemnation, even if human beings, by and large, are not. Whatever you feel about providing a home for homeless cats, I think New London could have found the cheaper and easier way to do this than condemning a lot of property and spending millions of dollars. They could easily have set up these cats in much higher style than they currently reside in on the Kelo condemnation site, and yet spent vastly less money than they actually did. So this pattern that you see in Kelo is far from unique. There are many examples of economic development taking which resulted either in no development or, more commonly, in much less development than was expected, with the result that more economic harm was inflicted by the taking than any actual benefit. Before Kelo, probably the most famous economic development taking in American history was the 1981 Pole Town condemnation in Detroit, where some 4,000 people were forced out of their homes and many businesses, schools, and other institutions were destroyed so that the land could be given to General Motors to build a new factory. The prediction was that the factory would create some 6,000 jobs. In reality, no more than half that number of jobs was actually created. And when you total up the costs of the takings and also the destruction of the businesses, schools, and other entities that were there before, it's almost certain that the city of Detroit lost out more economically than they gained from the Pole Town condemnations. And I think this is not accidental, because when you don't actually have to produce the economic development that supposedly justifies the taking, and when there are powerful interest groups such as General Motors in Detroit who can benefit from using this condemnation power to transfer property to themselves from people who are politically weaker, there's obvious incentives to create a situation where you get takings whose benefits are not worth the cost, even in purely economic terms. In the Kelo taking, out a similar situation in that you had the Pfizer Corporation, a major pharmaceutical firm which was planning to build a headquarters in New London. They hoped to benefit from the taking, and as the City of New London's own expert testified at the trial, he said that Pfizer was, quote, the 10,000-pound gorilla behind the taking, his words, not mine. So had a similar situation of a politically powerful entity really driving this condemnation, and at the expense of people who, for the most part, had very little or no political influence of their own. Now, it may be the case that this risk wouldn't be so bad if you had effective political constraints on these takings. So if the public could observe these takings and they see all you get is a colony of feral cats benefiting, then they can vote out the politicians who did it at the next election. That's how the democratic process is supposed to work. However, there's several severe obstacles to that kind of accountability. One is that voters have a strong incentive to be ignorant about most public policy issues. Why? Because if your only reason to be informed about politics is to be a better voter, to decide who will be the best mayor of your city or the best president of the United States or whatnot, that turns out not to be much of an incentive at all, because the chance that your vote will be decisive, will actually make a difference to the outcome of an election, is infinitesimally small. So most people pay relatively little attention to politics, and as I discuss in much more detail in my forthcoming book, Democracy and Political Ignorance, which I hope you all actually buy. Don't have to read it, just buy it, that's all I ask. If you buy the book, you will see that most people have a very low level of political knowledge. And this ignorance is a particularly serious problem in cases like monitoring economic development takings, where it actually requires a good deal of time, effort, and expertise to try to figure out whether a taking really did produce net benefits or not. Moreover, it turns out that in many cases we don't really know whether there's a net benefit until several years after a condemnation has happened, and you get a situation like this. By that time, public attention has generally moved on to other issues, and maybe the politicians who approved the taking are no longer even in the same offices that they were in before, so political accountability is relatively weak for these sorts of condemnations, and most smart politicians know that. Therefore, they know that if they exercise this authority to benefit powerful interest groups at the expense of those who are poor, politically weak, most of the time they can get away with it. Every once in a while, it's true, a case gets to the Supreme Court and it becomes a national scandal, but in most cases, the risk of that happening is actually pretty low. Kelo was the first public use case of this magnitude to get to the Supreme Court in over 20 years, and the first to be widely publicized since the 1981 Poll-Town case, so it doesn't happen that often. Now, I must admit that there is a potential economic rationale for these sorts of condemnations, and that is the so-called assembly problem. Imagine that you're planning to build a development project which is somewhat better planned than the one you see here, and let's say that it's so good that the new value of the land will be $1 million more than what was there before, but in order to develop your project, you need to buy out 100 different owners because the land is divided up among many different owners. If you start doing it, you might run into the problem that you go to the first person, they say, I'll be very happy to sell to you, but you've got to give me at least $950,000. You should still do that. There will be $50,000 of profit left over for you. Obviously, once you start giving people prices like that, pretty soon either you have to abandon the project or you're going to be paying out more money than the project is actually worth. So defenders of eminent domain say we need to be able to force these people to sell so that they can't hold out on the project. I think there's something to this argument, but I think it's also greatly overstated. One problem is in the real world of politics, there's no reason to expect that local governments will actually restrict their takings to these types of situations where it's actually the case that there's a holdout problem like this. Generally speaking, this will be driven by politics rather than economic theory. In Kelo and in Post-Kelo and other cases, there's not actually good evidence that there was a holdout problem blocking a project that was actually beneficial. Indeed, in Kelo itself, politically influential people such as the Italian Dramatic Club, a local bar where lots of powerful local politicians like to hang out, they got an exception from being condemned in the Kelo project because they had clout in the New London city government. Suzette Kelo, who was a relative nobody until this case occurred, and the other property owners were condemned. They didn't have the same influence, so they got condemned. In addition, where there is a genuine holdout problem, the private sector actually does have ways of getting around it. I can talk about them more in questions, but the most common one is using secret assembly. You start buying up the property, but you don't tell people you have a big development project. You just come up to a person and say, I'm a developer, I'd be interested in buying your house, but you're not saying I'm building a big factory or whatever. You might say, well, this would never work, people would find out, but in actuality, it routinely does work. This, for example, is how the Disney Corporation acquired the land necessary to build Disneyland. Is Disneyland this in Florida? Disney World, yeah, I always get them confused, but it's the one in Florida. That's what you need to know. Therefore, there are ways around the holdout problem, and in addition, there's no reason to believe that actual state and local governments will confine their takings to cases where there's a genuine holdout problem blocking a project that's genuinely more valuable than the existing uses of the property. So that, in a nutshell, is the problem with economic development takings. I'd like to now briefly talk about the Kelo case itself. As I noted, Kelo ruled that these sorts of economic development takings are consistent with the public use clause of the Fifth Amendment, and they did so by essentially holding that a public use is simply any conceivable public benefit. Any benefit that might potentially be created, even though they further indicated that the government doesn't actually have to prove that the supposed benefit is actually going to materialize, as indeed in this case it didn't. Now, interestingly, this was a very close 5-4 decision, and it must be said that many people, myself included, did not expect it to be close because, in fairness, in 2 previous cases, the Supreme Court had already said that the public use clause is defined very broadly, and that a public use is almost any conceivable public benefit. Nonetheless, I think there are still serious problems with the Supreme Court's decision, and it should have ruled the other way. I'm not going to go through all of them right now, but I'll just give you a couple of the highlights, or really rather lowlights. One big problem is that if you're an originalist, if you look back at the original meaning of public use, both in the 1780s or or 1790s rather, when the Fifth Amendment was first adopted, and in 1868 when it was incorporated against the states, although there was some disagreement, the more common interpretation of public use was that a public use had to be some kind of either actual ownership by the public, by the government, or that at least members of the general public had a legal right to use the property, as for instance with a public utility or the like. They did not accept the view that a public use is just any conceivable public benefit that somebody can come up with, because of course that really doesn't meaningfully constrain takings at all. Secondly, there is a deep internal contradiction in the court's logic in Kelo and other similar cases that we don't see in its treatment of any other individual constitutional rights. On the one hand, they say that you have an individual right not to have your land condemned for something that isn't a public use, for something that is really a private use that benefits a private party. On the other hand, they say that the scope of that right is going to be determined essentially by the state government. The state legislature gets to decide what is or is not a public use with almost no constraint. That is that the definition of the right that you have is going to be left up to the very entity that that right is supposed to restrict. There is no other constitutional right that's treated this way. It's kind of like saying you have a Fourth Amendment right against unreasonable searches and seizures, but who decides what's a reasonable search and what isn't? Well, it's the local prosecutor and police department, because they have the necessary expertise and they know more about searches and seizures than judges do. Even though they probably do have expertise, it makes no sense to do this because, of course, the whole point of the right is to constrain them, and exactly the same thing applies here. It's as if you said we have a problem of wolves breaking into chicken coops and stealing chickens, so we're going to appoint a committee of wolves to determine what the rules for access to the chicken coops are. If you're stupid enough to do that, what will happen is that the chickens are going to get plucked and there won't be any chickens left because the wolves will gobble them all up. And that's essentially what the Supreme Court has done with this constitutional right. They've thrown it to the wolves. Finally, there is a serious error in the court's analysis of precedent that has recently been admitted by no less than retired Justice John Paul Stevens, the author of the majority opinion in Kelo. In the Kelo opinion, Justice Stevens wrote that the idea that a public use is almost any public benefit is supported by, as he put it, a century of precedent. But if you actually look at the late 19th and early 20th century cases that he cites in support of this proposition, not a one of them is actually a case about the public use clause of the Fifth Amendment. In fact, most of them don't even mention the amendment. The one that does is a case which mentions it only to say that it's not relevant to the outcome of the case. What those cases actually were cases where takings were challenged not under the public use clause, but rather under the due process clause of the 14th Amendment. People were trying to challenge takings in that way. You might say, well, why weren't they using the takings clause? Did it just have bad lawyers? No, the answer is that at that time the Supreme Court had not really recognized the incorporation of the Bill of Rights against the states. So if you wanted to challenge a state taking in federal court, you had to use the due process clause of the 14th Amendment, the so-called substantive due process clause. Under that clause, it is indeed the case that the court was deferential to state governments, though actually not quite as deferential as later cases like Kelo were. But in the rare cases where they heard cases challenging federal government takings that actually did use the public use clause, they made it clear that actually a tougher standard applied, especially if the property was transferred to a private party. This was enunciated in the 1896 Gettysburg case for those of you who might be future Supreme Court justices and future Supreme Court clerks. If you want, you may want to read that case before you draw the conclusion that Justice Stevens did. In a speech that he gave in 2011, Justice Stevens admitted this mistake, and he called it a, quote, embarrassing to admit error. I think it is indeed embarrassing, and I hope the Supreme Court in a future case will in fact correct it. It is not my view that this mistake by itself proves that Kelo was wrongly decided, but I do think it's a weakness in the court's reasoning, and I do think it, combined with the other problems with Kelo, at the very least justifies the court in reconsidering the issue and considering whether Kelo should be overruled. It's rare that you have a major Supreme Court opinion where the guy who actually wrote it admits that he made a big screw-up in the opinion itself. Now, in fairness, he still maintains that the outcome it was correctly decided for other reasons, which we can talk about, which, by the way, no other Supreme Court justice has ever agreed with. So I'm not saying there are no other arguments in defense of Kelo. All I'm saying is that one major one relied on by the court itself has been admitted to be false, even by the author of the court's opinion. So in the aftermath of Kelo, you had an unprecedented political backlash. And you can see here, this is the results of a poll about Kelo taken a few months after a decision. And you can see that over 80% of the public disagreed with the outcome. And this disagreement, oh, I'm sorry, pressed the wrong button. Can we get it back? No. Just keep going. So over 80% of the public decided that they felt that they disagreed with the decision, and this disagreement cuts across the usual gender, racial, party affiliation, and ideological lines. And I could have put up here the results of many other polls with similar outcomes. Moreover, this degree of opposition has been pretty stable. Polls taken 4 or 5 years after Kelo, you get roughly similar results. In addition, as I noted earlier, 44 states passed eminent domain reform laws in the aftermath of Kelo, and not only was Kelo hated by most of the general public, but numerous political activists on both sides of the political spectrum denounced it. The NAACP was against Kelo. They wrote an amicus brief urging the court to strike down the taking. Many people on the right were against it. Bill Clinton denounced it. Ralph Nader denounced it. Rush Limbaugh denounced it. All sorts of people who don't normally agree with each other seem to be united in opposing Kelo. Therefore, it was understandable that many, including Richard Posner and others, thought that you don't necessarily need judicial intervention in this area because the political process will take care of it. Look how unpopular this is. Look how 44 states are passing new laws. And indeed, in some states, it is true that the reform laws were passed that were effective, but in a very large proportion of them, the laws that were passed were essentially largely for show and don't actually constrain these takings. You can see in the very first column up here that in states which enacted reforms just through the ordinary legislative process, there are 15 states with effective reform laws, by which I simply mean reform laws that provided property owners some meaningful protection beyond which they had before, and 21 states where they were ineffective in the sense that really the situation for property rights changed very little, if at all. There are many different ways in which these reforms were passed so as to render them ineffective, but the most common scenario, which by the way you also see here in Texas with Amendment 11 and also with the reform that your state legislature passed back in, I think it was in 2006, what they did essentially, and this was replicated in about 20 other states, what they did is they said, you can't condemn property and take it from one individual and give it to another for purpose of economic development. But you can do it if the land is blighted. And then they defined blight so broadly that virtually any area, anywhere could be considered blighted. So under definitions of blight similar to the ones that exist here and in many other states, such places as downtown Las Vegas have been declared blighted, in that case justifying a condemnation of property to give to various casino interests. And essentially, these laws define blight more or less in terms of economic underdevelopment. They essentially say that if it could be more developed than it currently is, then it's blighted, and therefore it can be condemned. So obviously that doesn't really meaningfully constrain eminent domain, even though it pretends to do so. Now it is the case that reforms enacted by referendum tend to be more effective, particularly those enacted through the citizen-initiated referenda, where it's citizen groups that can put the question on the ballot rather than as opposed to a process you have in Texas and some other states where they first go through the state legislature and only then go through only then get on the ballot. And of the citizen-initiated ones, 6 out of 7 were effective, and the legislative-initiated ones, maybe about half of them are effective, depending on how you categorize a closed case in Michigan. So Therefore, there is this big difference between citizen-initiated referenda, which almost always are effective, versus other reform mechanisms, and that cries out for explanation. There are a few states that have not enacted reform laws, where strangely enough the D got cut off from enacted. That symbolizes how those states didn't make any real effort, perhaps. But you can say, well, that's only 6 states, but it includes some important ones such as New York, New Jersey, and Massachusetts. So these states are insignificant. I'm sure the Yankees had something to do with what happened in New York. They have occasionally benefited from eminent domain in the past, among their many other sins. So I had to throw that out. This is a deep inconsistency in Josh's belief system. Yes, exactly. That's the first correct thing you said about the Yankees in a long time. So the political reaction to Kelo raises 3 questions that we would want to explain, or at least 3 questions. One is, why was there such a big backlash at all? As I noted, Kelo was probably only a modest change compared to pre-existing Supreme Court precedent. So if people didn't like these kind of takings, why weren't they angry before? Secondly, why is it that so many ineffective reform laws were enacted, given the overwhelming public support for changing this? And finally, why the difference between citizen-initiated referenda versus other kinds of reform laws passed by other means? I think there's a number of different factors which account for these patterns, but a big factor is political ignorance. The very kind of ignorance which made it difficult to monitor these takings also helped explain why people weren't angry before. Why? Because they didn't know about it. Most people who are not experts in takings don't keep close track of Supreme Court precedent in this area, don't know what the law in their state is on this, and so forth, and therefore before Kelo, before this highly publicized Supreme Court case, they simply didn't know that this was going on. After Kelo, they of course did know that it was happening and supported reform, but that doesn't mean that they can keep close track of their state legislature and figure out whether or not the reforms that were passed in their states actually were effective or not. So here, this is a survey that I was able to conduct in 2007, asking people whether they knew whether their state had passed eminent domain reform legislation since Kelo, and if they said they did know and they thought that their state had enacted a law, I asked them, do you think it was effective or not? And in both cases, they had a 50-50 chance of guessing correctly, even if they were just guessing. Despite this, only 13% of the public actually knew both whether their state had passed a reform law and whether it was effective or not. And that 13% is actually an even lower number than you would get if just everybody had randomly guessed on both questions. It's lower because a lot of people did admit that they don't know. Nonetheless, the 13% probably overstates the true level of knowledge, because we know that some people do guess on public opinion surveys rather than admit that they don't know something. You've all probably been taught to guess on standardized tests like the LSAT. If you don't know something, many people apply this wisdom to public opinion surveys as well. So this 13% is probably an upper bound on how many people really knew. And as you can see, the ignorance does cut across different racial and ethnic groups and different ideologies and so forth. So it is the case, therefore, that most people, quite understandably, simply didn't know whether a state had passed an effective law or not, and this created an opportunity for politicians. On the one hand, they felt that they needed to do something to appease public opinion. On the other hand, if they could avoid it, they would prefer not to rile up the interest groups that benefit from the status quo, powerful developers, local governments, and others, and therefore passing an effective reform law enables you to kill 2 birds with 1 stone. It enables you to say, I did something, but also not annoy the beneficiaries of the status quo. The third question is, why were citizen-initiated referenda different from the others? Why were they so much more likely to be effective? Well, the answer, I think, is not that the public was better informed about them. Rather, I think the answer is that these laws were drafted by different people. In most cases, they were drafted by property rights activists who really did want strong constraints in eminent domain and who didn't necessarily care whether interest groups were annoyed at them or not. So, of course, these people, most of them are not running for election to the state legislature anyway. They don't need campaign contribution. They don't need other things that these interest groups could give them. So they wanted to write strong reform laws. Now there is one exception here that really proves the rule. The one citizen-initiated referendum that led to an ineffective reform law is California Proposition 99, enacted in 2008. And this reform law was drafted by a citizen group known as the California League of Cities. Now, as the name implies, the CLC is an organization of local governments, the very entities that undertake these sorts of condemnations, and of course they like having broad eminent domain authority as they did under previous California law. So at this point you might ask, if they like the status quo, why did they bother to draft a referendum initiative that largely reaffirmed that status quo? I think the answer is that on the ballot at the same time was an initiative known as Proposition 98, which had been put on the ballot by a property rights group, and which, if it had passed, really would have seriously constrained eminent domain in California. So the California League of Cities wanted to avoid this, and they put 99 on the ballot to offset 98. 99 even included a provision which said that if both 98 and 99 passed, 99 would trump 98 so long as it got more votes. Now, as it turned out, 98 was defeated outright for reasons unrelated to Kelo that we can talk about, but of course the CLC didn't know in advance that this would happen, so this is sort of the exception that proves the rule. It shows that what's really decisive in many of these cases is who drafts the laws. Now, I don't want to paint too bleak a picture. In about 20 states or so, there were effective reform laws that were passed that made things better than they were before. So I think we are much better off since Kelo than we were previously in this area, but the reforms were not nearly as comprehensive and successful as you might predict based on the overwhelming public sentiment and based on how many states enacted new laws. In the last few minutes of the talk, I'd like to briefly talk about the judicial reaction to Kelo and how Kelo has been treated in state and federal courts since the decision came down. I think the biggest issue that confronted courts in the wake of Kelo is that state Supreme Courts in a number of states decided whether Kelo would be a guide to the interpretation of their state public use clauses. Almost every state has a state constitutional public use clause, which is worded very similarly to the federal one, and often when you have state constitutional provisions that are worded similarly to the federal ones, the state courts just use the federal court's interpretation of the federal constitution as a guide to how they interpret the state constitution. This is in fact exactly what happened when in the 1950s the Supreme Court issued Berman versus Parker, I think a much worse decision than Kelo, where they for the first time said that public use was almost anything that the legislature said it was, and in particular they authorized blight condemnations, and in the 20 years after that, numerous state Supreme Courts said, well yes, we adopt Berman as the interpretation of our state constitutions. In the aftermath of Kelo, you did not see this happen. In the 3 state Supreme Courts, which since Kelo have considered this issue, they all have explicitly repudiated Kelo and said that economic development takings are forbidden under their state constitutions. These are the courts of Ohio, Oklahoma, and South Dakota. A couple other state Supreme Courts, including Hawaii, while not directly confronting the Kelo issue, they've at least hinted that Kelo is not a comprehensive guide to how to interpret their state constitution. As yet, no state Supreme Court decision has actually explicitly said, yes, Kelo is a guide to interpreting our state constitution, and that's pretty significant, especially in cases like Ohio, where the wording of the state and federal constitution is very similar. Now, there is an exception to this pattern of generally unfavorable treatment of these kinds of cases in state Supreme Court since Kelo, and that is the conduct of the New York Court of Appeals, the highest court of that state, where in the 2 most controversial eminent domain decisions since Kelo, the Atlantic Yards decision in 2009 and the Columbia University decision in 2010, they essentially went in some ways even further than Kelo in allowing extremely dubious condemnations. In both of these cases, the claim was that the land in question was blighted, but New York defined blight so broadly that it went even further than other states with a broad definition of blight. They said that, quote, any area that is economically underdeveloped could be considered blighted. And in addition, you don't even have to prove that it actually is underdeveloped. All you have to show is that there could be reasonable disagreement over whether it's underdeveloped or not. I don't think you can show me a piece of property anywhere in the world where there couldn't be reasonable disagreement over whether it could be more developed. I could say that for Buckingham Palace. I can say that for the Empire State Building. I can say it for your backyard. This law school is definitely underdeveloped. There's no question about that. There's not even room for reasonable disagreement, perhaps. Therefore, there's no limit here, despite the fact that the New York State Constitution actually has an explicit provision authorizing blight condemnations, and that provision says you can only condemn property under this if it's, quote, substandard and insanitary. I think you don't have to be a takings expert to see that there's a bit of a difference between maybe it's economically underdeveloped versus it has to be substandard and unsanitary. Moreover, in both of these cases, the blight that supposedly justified the taking was found by a firm that conducted a study, and that firm had actually been on the payroll in the one case of Bruce Ratner, the developer who would get the Atlantic Yards property after it was condemned, and in the other case of Columbia University, which of course got the land condemned in the other case. And moreover, the firm had been given instructions by the relevant government agency, which essentially told them, I'm oversimplifying somewhat, but essentially told them, make sure you find some blight. They didn't say conduct an objective unbiased study. It essentially said, like, look for blight and find it, right? So it was not exactly an unbiased study. And finally, in both cases, much of the land in the area where blight was supposedly found was already owned either by Ratner or by Columbia, so in some cases there's at least some evidence suggesting that the blight in question had been created by the very people who would benefit from a finding of blight, which seems like a serious conflict of interest. However, relative to the jurisprudence in other states, the New York situation is somewhat of an outlier, albeit it's pretty important given how many millions of people live in New York and are potentially vulnerable to these sorts of takings there. The last issue, legal issue that arose in the wake of Kelo is the so-called question of pretextual takings. In general, as I noted earlier, Kelo allows the condemnation of property for almost any reason, but there is this one exception. They say that a taking where the official rationale is, quote, a mere pretext for some scheme to benefit a private party, that's still unconstitutional. Now, what does it mean to have a taking that is pretextual? The Kelo court doesn't really tell us, nor do previous Supreme Court decisions. Therefore, lower courts, both state and federal, have struggled with this in the aftermath of Kelo, and they've come up with at least 5 different approaches to what counts as a pretextual taking. One possible approach adopted by the Pennsylvania and Hawaii Supreme Courts is to try to look at what the motives of the condemning authority were. Did they genuinely believe that this was benefiting the public interest in some way, or were they nefariously plotting to benefit evil developers or Pfizer or feral cats or something like that? A second possible approach, one adopted at least one decision by the D.C. Court of Appeals, the highest court of the District of Columbia, is to look at the distribution of the benefits for the taking. If it looks like the distribution is overwhelmingly lopsided and there's some one private party, the new owner, that's getting almost all of them, maybe the taking is pretextual. A third, which you see in the Rhode Island Supreme Court, the Summit in Pennsylvania, is to look at how much planning was done before the condemnation. The Kelo opinion itself emphasizes that one reason to defer to the government here is that a lot of supposedly careful planning was done. You can see the results of that planning, but there was some indication that careful planning was done, so the implication is that if it doesn't look like very much planning was done, that's some indication it's more likely to be pretextual. Fourth, the federal Third Circuit Court of Appeals has emphasized in considering a pretextual taking claim, it's important to see whether there is a private beneficiary of the taking that is identifiable and whose identity was known in advance. If you don't know in advance who the new owner of the condemned property is going to be, the theory is it's less likely that the condemnation which is esteemed to benefit that person. Finally, the New York Court of Appeals in the Columbia case, and also the Second Circuit in a closely related case in the Atlantic Yards case, there was a federal Atlantic Yards case as well as a state one. They have defined pretext so narrowly that essentially it's impossible to find a pretextual taking anywhere. Essentially, they looked at cases where all four of these other indicators that are listed were present, and they said that's still not enough for a pretext. So if that's not enough, it's hard to see what would be. So the lower courts are all over the map on this, and I and others have been trying to convince the Supreme Court, so far unsuccessfully, to take another case in this area so they can clear up what counts as a pretextual taking, or better still, perhaps reconsider Kelo itself. So on that note, I conclude, and I look forward to the discussion. Thank you so much.
Thank you so much. One brief note for you to be aware of. One of the biggest issues for Texas right now, eminent domain, is the Keystone Pipeline. Everyone heard of that? A couple of you, I think, have asked me about it. So effectively, TransCanada, a company, wants to build a pipeline to transport shale oil from Canada all the way down to the Gulf. And they have to build pipelines going straight through, and actually some will come through Harris County. Currently, under Texas law, these companies are considered public utilities or common carriers. And Texas law is extremely deferential, so all those people are probably going to lose. You might have seen Daryl Hannah, some of the people climbing in trees trying to prevent the destruction. They're going to lose, and eventually TransCanada will probably get all the land they sought. There's a couple of cases going up to the Texas Supreme Court now. There are a few issues about whether, in fact, they are common carriers, because there's only one person allowed to use a pipeline. They're going to lose. But it's something to be aware of.
If they're really not common carriers, they might win.
Well, we'll see. The Texas Supreme Court's actually been fairly pro-property of late. They had a very good rolling easement case from last year. And if you had me for a class, whatever we did, and when I talked about Kelo, if it sounded familiar, that's why. Got it from him. Okay, I will pose the first question and ask Professor Somin, what do you think the chances are that the court will revisit Kelo? And if so, do you think there'll be enough clout or enough effort for it to reverse it or perhaps appeal it back? Or more precisely, what would a scaled back Kelo look like?
It's a good question. So I think it is very likely that sooner or later, I would bet sometime in the next 5 to 10 years, or even sooner, the court will take up this pretext question and try to figure out what a pretextual taking actually is. So if they were to scale back or overrule Kelo, the one possible scenario is that they would adopt one out of these four approaches that I mentioned, or perhaps even all four of them. They might say, if any of these four things is present, that's a strong indication of pretext, and at that point the government must closely scrutinize, or rather the court must closely scrutinize the taking. That would not be overruling Kelo, but it would be limiting its impact, because there's actually a lot of these takings that have at least one of these four indicators that I previously listed. The court could potentially decide to overrule Kelo itself. It's possible that Justice Kennedy, who is the key swing voter in Kelo, could potentially flip. He wrote a concurring opinion, which was sort of equivocal on a number of key points. That said, I would feel better about the prospects of overruling Kelo if one of the people who had voted in favor of it had been replaced by somebody who was likely to vote against, which so far has not happened. We don't know for sure, however, how Lena Kagan feels about these issues. We do know that, unfortunately, that Justice Sotomayor wrote what is probably the single most egregious post-Kelo lower court decision, the Didden case, which I testified about.
He testified
at her confirmation
he testified
hearing.
for the Senate against Sotomayor.
Merely against the President in this one case, but which is a pretty crucial one, because essentially this was a case where a developer had a contract to develop property in an area, and he went to people who were trying to build a CBS there, and he said essentially, either you have to pay me $800,000, or you have to give me a 50% share in your business, or I'm going to make sure that your property is condemned and given to me under this redevelopment plan. And they said, we refused your offer. So the very next day, the land was condemned. And I know there's debate over what counts as a pretextual taking, but it seemed to me that if anything is pretextual, it's outright extortion like this. Yet nonetheless, Sotomayor wrote an opinion when she was a law judge where she said that under Kelo, this taking is permissible. I could go in more detail about it, but I think it's indicative.
There's a question in the back?
Yes.
No, we're just on.
So nonetheless, I think it is time, or really past time, to throw it out to questions from the audience. You might even also turn on the lights further.
I got it. All right, any questions?
Yes.
If you could rewrite the opinion, or if reform was, if you had a say in the reform, what would your stance be?
So these are two different questions. Writing to reform, I think there's two options, both of which you see in some states. One is to ban economic development takings and then define blight narrowly, the way that you and I, or not you and I, but lay people might define it as really actually dilapidated or dangerous property. Quite a number of states have taken this approach, and I think that's certainly been an improvement over the status quo in those states where blight is defined super broadly. Another approach that only a couple of states have adopted, including Florida, is to actually categorically ban blight takings as well. I think this more radical approach is actually better, because even if the area genuinely is blighted and there is a real problem, it doesn't follow that we need to destroy the neighborhood through eminent domain in order to save it. There are other better ways of approaching that problem. When you have condemnations in genuinely blighted areas, what you typically see is the poor people in that area get condemned and forced out, and often end up in worse conditions than before, and it's not even clear that the property necessarily will end up being better off, but the people certainly will be worse off. This is actually what happened in the 1954 Berman versus Parker case that I mentioned, where over 3,000 people in Washington, D.C. were forced out, almost all of them poor African Americans, and the land was given to development interest, and those people, although they had been living in bad conditions before, their situation was even worse afterwards because their lives were disrupted, and it's not like they got to live in middle class housing. They ended up moving to other poor neighborhoods elsewhere, and they had in the meantime lost their former homes and social ties. So I would ban the blight takings categorically, but the best should not be the enemy of the good. Defining blight narrowly is still better than defining it broadly. As to how I would have written the decision, I think you have, again, narrower and broader options. I would at the very least have done what Justice O'Connor advocated in her dissent for 4 justices, where she said that economic development condemnations are not a public use because any connection to a public benefit is too attenuated. She differentiated that from blight condemnations. But I think, as a matter of logic, Justice Thomas's sole dissent may be better, where he said that really blight condemnations that transfer property to private parties, they have the same ultimate constitutional problem, that there's not a real public use. The advantage of O'Connor's approach is that you don't have to overrule Berman versus Parker, and you don't have to overrule a 1984 case that was somewhat similar, known as the Midkiff decision. What you would do is you would leave those precedents on the books, but you would cut out the language in them which said that a public use is anything that's rationally related to a conceivable public purpose, and you instead adopt the test that O'Connor advocated and that exists in a number of state Supreme Courts, where you say that a taking that eliminates a pre-existing harm like blight, there the land can be transferred to private parties. But if the idea is to create some kind of just nebulous economic benefit, then that's not a true public use. So to my mind, that's not as correct as simply saying a public use is ownership by the government or some kind of public utility where the general public has a right of access. But I can understand people who are less willing to overrule precedent than I am, who might prefer O'Connor's approach.
There's time for one more question. Listen.
This is slightly off point, so if someone else has a more on-point question. Do you view the Endangered Species Act regulation on land use as a taking, or just land regulation?
So this is raising the question not of whether a taking is for a public use, whether something is a taking. To make a long story short, I would say that there are some regulations under the Endangered Species Act which are probably not takings. There's other ones which I think are. The ones which are ones where it essentially says there are situations where you can't do any development whatsoever, almost any development on your property if there's an endangered species. There I think it is a taking, which by the way doesn't necessarily mean that it's never worth doing, right? The fact that it's a taking just means that the government would have to pay compensation for it.
Litigate.
No, they don't necessarily have to litigate. If their two sides agree without going to court, you don't have to go to court. You don't have to litigate anything. If you're interested in this, there's some excellent work by Jonathan Adler of Case Western Law School, who writes about how the Endangered Species Act would actually operate better if the government were required to pay compensation in such cases. Because under the status quo, if you're a landowner and you find some endangered species on your property, your incentive is to off the endangered species before the government finds out about it.
I swear, did I tell you this last semester?
People have actually done this,
Kill
including
the endangered species. You don't call them. That's what you do.
Yeah. So if possible, the self-interested landowner would kill it, but at the very least, you certainly wouldn't tell the government that it's there, right? Because then there would be restrictions on development. So it's both in the United States and, by the way, also in places like Africa. When you have a situation where the government cooperates with the landowners to try to protect the species and pays them for their losses, you're more likely to achieve your goal than if you essentially wage war against the landowners, because if you do that, then they may respond with scorched earth tactics of their own.
There's a question right there?
Yeah, I just have, what's the next logical extension of Kelo? Just like, if there's another step that
To go even beyond? What do you mean by extension?
As in, like, it started off with eminent domain for public use, now it's going to private. Is there one more that you would see in the near future?
So, Kelo itself is going pretty far, and remember they said that virtually any potential public benefit is a public use, so long as it's not pretextual. If you wanted to extend it further, you can imagine the Supreme Court doing what Sotomayor did and didn't, or what the New York Court of Appeals did in the Columbia case, which is to say that either pretextual takings are also okay, or you define pretextual so narrowly that nothing could be considered pretextual. So that then would be instead of Kelo's almost anything goes, that would be truly anything goes.
All right. That's about the time we have, Ilya.
And convince this guy not to be a Yankees fan and make him read the Lord of the Rings.